Time is now 8:45. 19-year-old Carmelo Anthony has been convicted of the murder of 17-year-old Austin Metcalf after stabbing him at a high school track meet. This happened last April. According to witness testimony, Anthony entered a tent that belonged to Metcalf's team and then stabbed Metcalf once in the chest after an argument. Anthony's defense team said that he stabbed Metcalf in self-defense, acting out of, quote, a split second of fear and chaos after Metcalf pushed him. The teens did not know one another and were from rival high schools.
We're bringing in our chief legal analyst, Kali Frodes, once again to talk about this. In the defense, right? They're talking about this was self-defense. And what I found interesting was something that I haven't heard of. The jury was allowed to consider sudden passion. Yep. Can you explain that? And it also would have changed the sentencing guidelines from 2 to 20 years in prison instead of 5 to 35.
You're all over that, and it's 5 to 99.
99,
not
excuse
35,
me.
But 100%. A couple of things to unpack. We need all week to unpack this entire case, but I'll start in the beginning. First of all, cases in states are not the same. And so North Carolina, when you see first-degree murder, you're thinking life without parole or the death penalty in our state. Well, in Texas, that would be their capital murder. So when everyone is saying, hey, he's charged with first-degree murder, that's similar to our second-degree murder. They don't have premeditation or deliberation. They're in in Texas, like we would for that. It would only be required that there was a murder or a crime committed. And so when you talk about that sudden passion, this is that immediate. It's arising from an adequate cause, like it's a rush, it's a speed, it's in that moment. You don't have time to think about it. It's kind of like heat of passion for voluntary manslaughter, but not as far. And yes, it would have been something where you would have needed to prove that defense. But I wanted to make sure I got that out of the way where folks were like, well, there was no premeditation. It wasn't required by the statute in Texas for that law. And so you also have some misunderstanding of the law in there where folks say, well, he was not in a place where he lawfully was allowed to be, because that's more of a stand your ground argument. Stand your ground laws say you don't have a duty to retreat as long as you're in a place where you're lawfully allowed to be. Well, Texas doesn't have stand your ground statutes, but this wasn't the argument that the defense was raising. It wasn't a stand your ground defense. It was just rooted in self-defense. And so you do have it right, even if you are a trespasser. Cases have found in Texas and other places specifically that if you are a trespasser, you do have a duty to protect yourself in self-defense situations, i.e. which would have been here if the individual which was testified pushed him first. You have a duty and an obligation, I should say, a right to protect yourself. It just has to be justified. And the jury found that self-defense argument was not justified there.
Anthony was 17 years old at the time. He was tried as an adult, though. Is that common in Texas? And how does that change the punishment?
It doesn't, and it is common in most places. I mean, you had to raise the age in a lot of places because North Carolina was one of the last states, I should say, making the correlation to raise that. Here in our state, you could be 15 at some points, 14, and be charged like an adult. And so that at 17, that is common when you're charged with violent types of crimes to be charged as an adult. And no, the sentencing guidelines and range would not have changed. The only thing that would have changed is was Annie had mentioned that if they would have recognized that sudden passion defense, then it would have been in that 2-year to 20-year time frame as opposed to 5 to 99. And obviously, if you would have found that it was a full self-defense, that would have been an affirmative defense, and the case would have been removed. But I think looking at, again, unpacking the facts of the case and the sentencing aspects, there's still an opportunity for them in terms of the defense side for appeals, and you want, as an attorney, to do all the things right to put your client in a position that they can preserve appeal down the road. Looking at the jury makeup and the jury selection process, there were a number of challenges to black jurors. And while this jury was made up of white, 100% white jurors, there's no guarantee by law that you have to get a black juror on your jury, but it has to be a fair cross-representation of the community. That's the first aspect. But I think there will be a Batson challenge, and that's the second aspect. Batson says if you are striking individuals from the jury because they are black, then you can challenge it. So during the course of jury selection, his defense attorney raised it 3 times because he said, hey, the prosecutor's only striking these folks because they're black. The prosecutor came back and said, no, I'm striking them because they're teachers. well, then they ultimately kept a person that was a teacher that was white. And so if I see any challenge to this case in terms of appealable, it's going to be procedural based on a Batson challenge to the jury selection of those three during that last couple days, or I should say that last moments of jury selection. But yes, I think this is right along where I suspected it would land, but there is an appeal aspect there down the road.
Yeah, and we'll keep an eye on those appeals. It'll have some pretty big implications. So, Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.